Ladies and gentlemen, my name is Linda Hosea. I'm a student at Bishop Stewart University, Faculty of Law. Ladies and gentlemen, we'd like to thank God so much first for this great evening He has granted to us. Today, I'd like to talk about the rule of law. The rule of law. Bishop Stewart University, we have the rule of law. And our values, we have accountability, we have transparency, trustworthy, and neutrality. Ladies and gentlemen, rule of law simply means everything must be done according to the law. Ladies and gentlemen, as I have earlier communicated, I'm a law student. Using the Constitution of the Republic of Uganda 1995 Constitution, it simply defines the rule of law in Article 21 as it is enshrined there. Ladies and gentlemen, Article 21 of the Constitution 1995 provides that equality before the law, which means that everything must be done according to the law, must be done according to the law. In the book of Professor Lise, 1885, he propounded the book, and in his book, the law is supreme and it applies to everyone, irrespective of their social, irrespective of their economic, irrespective of their political status. Professor, this is called, there are only three things. The first thing is about the supremacy of the law. Article 2 of the 1995 Republic of Uganda Constitution provides for the supremacy the supremacy of the Constitution. The Constitution, it is the supreme law of Uganda, and it shall take out the precedents. It is the supreme law of the land. Article 2 of the Constitution, clause 2, is to the effect that if any law or custom that is inconsistent with the Constitution, that law shall be declared null and void to the point of its inconsistency, and the Constitution shall prevail. Ladies and gentlemen, I'd like us to briefly talk about a case in the point, the case of Salvatore Aboki versus Attorney General. In that case, Justice Okara held that if the purpose of the Constitution infringes, if the purpose of the statute, any statute infringes, remember it was the Witchcraft Act. There was a section of the Witchcraft Act which was inconsistent. If the purpose of the statute infringes the right granted by the Constitution, that impugnated statute shall be declared null and void. That's about the supremacy. The way how I can talk about the supremacy. Consider the case of Paul Sekesomwe versus Attorney General. There was a law which was passed without quorum, which was declared null and void. Consider the case of Charles Onyango Obo and Andrew Mwenda Mushoni versus Attorney General. In that case, we see Justice Mulenga, the way how he espoused of the fact that in that case, that the granted rights, they are the primary objective. And the exception, it is a limitation, which is the secondary objective. He also said, Justice Mulenga, in that case, that also the Constitution, as I have already provided the Constitution as the supreme law of the land, also the Constitution provides for both. I have mentioned it, guaranteed right. I have mentioned it, the limitation. It is obvious that the primary objective must be dominant. Ladies and gentlemen, that's about the concept of the supremacy of the law as it was stated by Professor Desi. Another thing, the concept of equality is the second one, which requires every person to be equal before the law. As I have said that Article 21, it is enshrined that every person must be equal before the law. Ladies and gentlemen, if I talk about that, here I mean disputes or conflicts as to the legality are to be decided by an independent judiciary. In maintaining the rule of law, the judges should decide cases that come before them in accordance with the evidence adduced and should not be influenced in any way by extraneous matters. Ladies and gentlemen, I'd like also to bring Article 28, which is in relation to that. Article 28 of the 1995 Constitution, it provides for a fair hearing, a fair, speedy, and public hearing. The rationale behind that article, the rationale or the reason behind Article 28 is that in determination of civil rights and obligations, or any criminal charge, every person is entitled to a fair, to a speedy, and a public hearing. I can talk about Article 28 and I leave Clause 3, which gives the prosecution side to prove the accused is guilty beyond reasonable doubt. Article 28, Clause 3, A, Paragraph A, provides that a person is presumed to be innocent until proven guilty. Ladies and gentlemen, for example, those who are studying law in every institution or in every institute in Uganda, those who are studying law, those who are in Makerere University, those who are in UCU, Uganda Christian University, those who are in Nkumba University, those who are in other faculties of law, I try to tell you to bring something about Lord Viscount Sankey in the case of Wilmington versus DPP. In that case, when we see the presumption of innocence, Wilmington in his aspect, the way how he was charged with murder, but he was lacking something in his mind. He was lacking an intention. He was lacking mens rea. As you all know that, for an offense to constitute, so an offense to be an offense, for something to constitute an offense, there must be an act, and there must be an intention. Actus reus. We call it actus reus and mens rea. To expound more on actus reus, it is a physical element of the crime. Actus reus, in some situation where a person fails to do what he's supposed to do, fails to act, it would mean omission as well. Briefly on mens rea. Mens rea, it is a mental element. You know, nowadays in the court, when they are going to charge someone of an offense, they need to consider the mind. They need to consider the act, whether you acted or whether you intended to do that. In the case of Wilmington versus DPP, in that case of Wilmington versus BPP, we saw Reginald Wilmington was lacking unnecessary mens rea. And that's why Sankey Viscount, in that case, he was the one who ruled that case. Sankey Viscount, Lord Sankey Viscount, he stated, throughout the criminal law, there must be one golden thread had to be seen, that it is the duty of the prosecution. It is the duty of the prosecution to prove accused is guilty beyond reasonable doubt. That's how I can be able to expound on the equality, the concept of equality as stated by Professor Disi in his book, 1885. As I conclude on the rule of law, the rule of law only prevails when certain requirements are fulfilled. For example, the government should be conducted with a framework of recognized rules and principles that don't restrict discretionary powers. Under the rule of law is applicable through observation of human rights. If I talk about human rights are the rights of individuals. They are the rights of the persons because he or she is a human being. According to 1995 Republic of Uganda Constitution, the Republic of Uganda Constitution 1995, Chapter 4 vividly provides the fundamental of human rights. And the case of Reverend Christopher Mitkela versus Attorney General, human rights are the gifts of the individuals. They are not the gifts of the citizens. They are the gifts of the citizens, but they are not the gifts of the state. They are the gifts of the citizens, they are not. They inhere in the person from the past, prior to that, according to the law. So as I talk about human rights, briefly, human rights, they are the rights which a person can inherit, and no one shall be able to take them. There are many rights when you read Chapter 4 of the 1995 Constitution of Uganda. You will be able to get more, to expound more, to find everything in that Constitution. Everything shall be sorted there. That's how I can talk about rule of law briefly. There are many things I have left out, but the rule of law simply means everything must be done according to the law. Thank you so much.